Good morning, everybody. Welcome to the Courtroom Files Live. It is May 1st. I can't believe it's May already. Let's start our May off with Judge Simpson, 14A District Court, Washtenaw County, Michigan.
There's a conflict either in the Michigan court rules or the case is decided thereunder. To the extent the conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. People of the state of Michigan versus Carista Riopel.
That's one of the people.
Really?
Morning, Your Honor. Mike Geddes, defender on behalf of Carista Riopel, and I'd like to.
That's okay.
Akinruli.
Ms. Akinruli, nice of you to join us.
Good morning, Your Honor. I apologize, Judge. Yes, Your Honor, Assistant Public Defender Tanazi Carey Akinruli on behalf of Ms. Carista Riopel. Ms. Riopel, could you state your name for the record, please?
Carista Riopel.
Riopel. Judge, we are asking for an adjournment today.
Of course.
Yes, we are. I know we've asked for a few adjournments in this matter, but we have been able to meet with her. My social worker is asking for 3 weeks. He has one more meeting that he wants to schedule with her.
Probable cause conference will be adjourned May 22nd. 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. Thank you, Ms. Riopel.
Right. Thank you.
Court does call the case of the people versus Walter Peterson.
That's one for the people.
Harvard, on behalf of Mr. Peterson.
Ms. Cannon, if you had fallen, I would have just laughed. You know, I'm just gonna let you know. I would have asked if you were okay, but I really wouldn't laugh.
I would just say
Can't do it today. Could Mr. Peterson, please state your name for the record.
Walter Peterson. Thank you.
And Your Honor, at this time, we are asking that the matter be set for preliminary exam.
Discovery is all complete.
There's one last video I'm disclosing today, Your Honor. I do expect it will be complete by later today.
People would have their witnesses available the 13th.
We'll try, Your Honor.
Preliminary examination will be set in person, May 13th, 2025, 9 a.m. before Judge Valvo.
Thank you, Judge.
Bond will continue.
Thank you, Your Honor.
Thank you, Judge.
Calls case of the people versus Cameron Hanlon. Excuse me.
That is for the people.
Bill Smith, on behalf of Cameron Hanlon, Senate Cameron, state your name for the court.
Cameron Hanlon. Thank you.
Your Honor, we're looking for an adjournment of 4 weeks, if we may have it. For context, this incident occurred in the context of a crisis hospitalization of Mr. Hanlon's. He was then hospitalized for 2 weeks. There's records out there that I want to gather and then put together a mitigation package for the prosecutor to consider.
No objection.
There's no objection, Your Honor.
Probable cause conference will be adjourned May 29th, 2025, 9 a.m. Bound continue.
Very good. Thank you.
Thank you. Court calls case of the people versus Lozelle, Washington.
Edward for Lazar, Washington.
State your name, please.
Hello, my name is Larzell Washington. Larzell O'Neill Washington, sir.
Thank you.
Your Honor, I have a green sheet filled out there. I'm asking for an adjournment to continue negotiations. There's been an offer to a misdemeanor in this case. He does need to get screened for the 14B recovery court. It's not a contingent that he gets in, but he needs to get screened.
And that's part of the arrangement or the plea deal.
That's correct.
Part of that.
We've both signed that. We would need your signature in order to record that.
Did you have an estimate as to how long they're taking at this point to do the
I'd ask for 2 weeks.
probable cause conference in this case will be adjourned at 2025, 9 a.m. Bond continue.
And I would actually ask to address bond at this time.
Go ahead.
Mr. Washington was originally arraigned on March 27th. They set up probable cause conference for March 27th. He did not remember what the date was. He then did have an interaction with the police where they weren't actually looking for him, and they found out his name and located a warrant, so he was picked up. He was arraigned in this.
What kind of interaction with the?
He wants to address that.
This young lady I knew was being basically stalked.
That what?
She was being stalked and she was panicking. So I walked past her and told her, you know, leave her alone, leave him alone before he hurt her. And so they kept asking me the guy's name. You know, I couldn't, you know, tell him his name. Then, you know, the guy inquired on who I was. I normally sell ground cover news. It wasn't no problem on my end. And I'm happy. I didn't know the courthouse was this close. I would have been down here.
So I do have a contact number for him. He indicates that he would not object to any community corrections order.
I'm not going to change the bond. We'll see what the screening reveals, and then I'll take a look at the whole package.
Okay.
All right.
Thank you.
So motion for objections denied. Bond will continue.
Oh, Pete, no, Pete, come on, man.
Want me to do something different? Because you don't want it. Don't walk out of here like that.
Yes, sir.
Thank you, Ryan. I'll obtain a copy of that order.
Oh,
Man.
doing what I can to make people happy. Court calls the case, People versus Larry Hickman.
Good morning, Your Honor. Assistant Public Defender, Chinasa Carey Akin-Rulli, on behalf of Mr. Larry Hickman.
Oh, on time. Go ahead. What? All right. Mr. Hickman there?
Yes, Your Honor.
All righty. Thank you. Go ahead.
Judge, I was in communication with the people. They're probably going to file additional charges. We're not sure if it's going to be attached to this case or it's going to be a separate case. Is that correct?
That's correct. I followed up with the officer and I believe there will be sufficient charges that I'm still waiting to hear. So hopefully by that week.
So we're asking for an adjournment, Your Honor.
I do it this way then. Probable cause conference, May 22nd, 2025, 9 a.m.
Thank you.
Bond continued. Thank you. Court calls the case, People versus Shaquanda Hall.
David Knight, appearing on behalf of the defendant, Your Honor. My client is in California. She should be on Zoom, Your Honor. Thank you.
So can you unmute, state your name, please?
Shaquanda Hall.
All right. All right, what are we doing on this?
I was just retained last night, Your Honor, and respectfully request an adjournment for the opportunity to review discovery. Thank you.
That objection, probable cause conference, May 15, 2025, 9 a.m. Bond will continue. Thank
you very much, Your Honor.
Thank you. Court calls the case, People versus Sean Odom.
Your Honor.
Good morning, Your Honor. Brandon Bird on behalf of Sean Odom, PA 3734. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You up?
Yes, sir.
Respectfully, Your Honor, I did get it. I know I got a motion for adjournment in there right now, but I did get a chance to speak with my client, and he'd like to set this matter for exam. I did get all discovery in this matter.
So all discovery is complete?
As far as I know, yeah.
People have their witnesses available the 13th.
Your Honor.
Preliminary examination in person, May 13th, 2025, 9 a.m. before me. Bond will continue.
To address bond, yeah.
Go ahead.
Client, 40-year-old, 6 kids, 2 of them are grown. He helps raise them all. Lifelong resident, Your Honor. He is employed. He's trying to get back to being able to support his kids in this matter. I do understand this is a domestic violence third offense notice. My client indicates to me that he came in contact with the police because he actually went to the police station to file a report on the complaining witness. The complaining witness showed up to his job, and because the complaining witness showed up to his job, that was counted as contact. As soon as that matter happened, my client, out of his own volition, called his probation agent, called his probation agent to see what he should do. Probation agent told him, go to the police department and put in a report. When he put in that report, he turned around and got arrested in this matter. I do believe he was arraigned on his probation violation, in which he indicates to me that he received a $100 bond in that matter. I'm not definite, but I'm pretty sure the court probably knew about this case when they gave him that $100 bond, because this case stems back from March 28th, Your Honor. Respectfully, my client understands no contact with the complaining witness. At this point, he doesn't want any contact with the complaining witness. He didn't want contact with the complaining witness when he came into contact with her at his job. So respectfully, we're just gonna ask for a personal bond. My client doesn't mind the tether if we have to do a tether. This is a relationship where both of them need to stay apart from each other. He was doing his due diligence to stay apart from her. And just respectfully, Your Honor, we're requesting a lower bond, hopefully a personal bond, so he can at least get back to work and take care of his children, Your Honor.
Response.
Your Honor, I would strongly object to any change in his bond. I believe it's set at 50,000 cash surety at the moment. Mr. Odom has a lengthy history of dismissed DDs as well as DD conviction from just this year, with the same victim for a DD second, which is pled down. He's currently on probation for that and violated his probation with getting this new case. In the report for his bond violation, the victim informed officers that she let him borrow her car because he had nowhere to stay. She asked for the car back, he came back to her house and was yelling at her. And she also stated that he pulled out a knife while he was there. So I have great concerns that he can't follow court orders and wouldn't keep getting in contact with the victim and wouldn't be able to stay away, given that he's already on probation for domestic violence with the same victim.
Yeah, and there's ways to mitigate these circumstances. And the way we can mitigate that is with a tether. Obviously, the
I don't know that a tether stops a knife, but go ahead.
I'm not saying the tether stops a knife, but at least it'll let you know if he's around the complaining witness. And if he was there and they could come get him right away.
And Your Honor, I did also want to inform that previous case that was pled down was a previous FA with the same victim. And then in the underlying case of this case with the same victim, he grabbed her by her hair, pulled her into the living room, a fighting suit, and in the process of that, he hit her child in the face, he punched him, leaving him with a black eye. That's the underlying case that was out on bond for. So I have great concerns.
And that he's still innocent unless proven guilty beyond a reasonable doubt to, Your Honor.
Motion for bond reduction denied. Bond will continue.
Thank you for hearing me out, you know.
Well, he's between contestants. Good morning, everybody. Welcome to the Courtroom Files Live. Happy Thursday, May 1st. I cannot believe it's May, as I have put in the poll. Feel free to participate in the poll. It's nice to have you all here. Everybody's off to a fairly busy start in the courtrooms, it would seem. We'll continue to ride with Judge Simpson for just a little bit. I'm excited about today. I'm so excited that I broke with what I normally do with my morning routine, which is exercise and then do a homemade protein smoothie. I instead went and got donuts, so I'm being a bad boy today, but that's all right. Let's get back to Judge.
Michigan State University.
Mr. Smith, I would advise you to not speak at this time. Mr. Smith, just let us handle the matter, please. Your Honor, I provided the court with an order. Mr. Smith met with the forensic center who deemed him incompetent but restorable. We have no objection to those findings and asked the court to give him time to be potentially restored.
Any additional information from the people?
No, Your Honor. The people would stipulate to the report as well. Thank you.
All right. Court, upon reviewing the report, would find at this time he's incompetent to stand trial, but likely to attain competence provided the course of treatment. Given that, the court will sign an order to that effect. And I've signed that order. I will adjourn this for a competency review to 90.
Judge Simpson.
I'll set a competency review for July 30th. July 31st, 2025, 9 a.m.
Okay, can I speak with you now, Judge Simpson?
Mr.
Can
Smith,
you what?
I need to speak with you because I need to ask you some questions. I know they deem me incompetent, but Judge Simpson, my safety is at threat in this jail. I'm strong. Judge Simpson, they've been breaking me down mentally, physically. They've been stripping me of my dignity. The COs and the inmates are in cahoots.
Okay, Mr. Smith, Mr. Smith.
I need Judge.
Okay, just listen.
Judge
Hey,
Simpson.
hold on.
Yes.
I've given you another date. You're gonna get a chance to come back and talk, okay?
Yeah, because it feel
But
like.
right now, you're gonna have to talk to some other folks.
I'm out today, you said, Judge Simpson?
What'd you
Judge
say?
Simpson, excuse me, sir? Yeah, I'm strong. I'm out today.
No, not today.
Mr. Smith, you're gonna,
Judge Simpson, what this jail is doing, they trying to attack Judge Simpson. Believe what I'm saying.
Mr. Smith, you're gonna get some mental health treatment. Please call the public defender's office.
All right, Mr. Smith, contact your attorneys and we'll see what we can do, okay?
How long do I'm not even suicidal, Judge Simpson. They got me in.
All right, Mr. Smith, I'm done.
Judge Simpson.
Thank you.
I'm not gonna do nothing about my.
Thank you, Mr. Smith.
I can't even call my mom. They got me in the suicide.
Court does call the case, People versus Amanda James.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. May it please this honorable court. Oh, well, I'll yield the floor to sign. Oh, okay. Good morning, Your Honor. For the record, Rita Young appearing on behalf of Miss Amanda James, who is present and standing to my right. And today is the date and time set for a probable cause conference, Judge. And there has been an offer made. I don't know if the court's received the printout yet.
I have. I've received a plea sheet that indicates she's going to be pleading to 3 misdemeanor charges.
Yes, Your Honor.
The stated count 3 of operating with the presence of a controlled substance, the crime of operating either with no license or multiple licenses, that's count 4. And then also an added count 5 of use of a controlled substance, a 1-year offense. On her successful plea to those guilty plea to those charges, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
And Judge, there was an agreement by Mr. Childers and myself that she could be sentenced under 7411, but the plea form indicates it's only applies to count 5, and I asked that he agreed that it also apply to count 3, which is the presence of.
And Your Honor, it can't, as the court's aware, it can't.
Yeah, I didn't.
7411 doesn't.
I don't think it can.
Very well done, Your Honor. I believe that my client wishes to proceed with the offer. She has been advised.
Did she sign an advice rights form?
No.
All right, I'll get you to sign one.
Your advice, we went over. Just sign.
With
Yep.
Let's have her sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
I do.
State your name.
I'm Anthony.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 3 charges. Is that your understanding?
Sure.
All right. First of all, that you'll be pleading guilty to the charge of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. Also, then count 4, operating with no license or multiple licenses. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that?
Yes.
And then also the added count 5 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you'd be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes, Your Honor.
All right. Now, understanding all of that, ma'am, do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of operating with no license or multiple licenses, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights that are on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
because you believe that you're guilty of these charges?
Yes.
On February 9th, 2024, at the location of Ann Street in the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
Was that cocaine?
Yeah.
All right. Were you stopped by the police or was there an accident?
I was approached by the police while airing my tire. I'm not sure if they seen me exiting my vehicle prior to them approaching, but
They approached you because there was no air in your tires?
I was pulled over on the side of the
Side of the road because your tire had gone flat? Okay. And after they approached you, were you ultimately arrested?
I was detained, yes.
Pardon?
Yes.
All right. Were you taken to the hospital for a blood draw?
Yes.
Did that blood draw show the presence of cocaine and or its derivatives?
Yes.
All right. Do you have any reason to dispute those blood test results?
No.
All right. And at the time that you used the cocaine, you knew what you were using was cocaine?
Yes.
Pardon?
Yes.
All right. And at the time also that you operated the motor vehicle, did you have a license?
No.
Okay. Never had a license?
I've had a license. It was just a
But
start.
at that point, had no license.
Correct.
Correct. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people.
Yes, Your
are
Honor.
Court will accept the defendant's pleas of guilty to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report as well as screening assessment is ordered at 14A2 probation. Sentencing will be May 14, 2025, 10 a.m. before Judge Barr.
May I address bond, please?
Can I stop you? No, go ahead.
Of course you can. Miss James, she's 45 years old, Your Honor. She resides at the address that's listed in her file. She's a certified nurse assistant and provides home care to a patient that she's had for 7 years. Her bond is currently set at 10,000 cash or surety, and that was because she appeared by Zoom for a probable cause. No, she appeared by Zoom for an arraignment and then thought she could appear by Zoom for the probable cause conference, was told that she could not make it to court in time. Her attorney was not able to get a new date, so the bond was increased to $10,000 cash or surety. We're asking the court to please reinstate her $5,000 personal bond, which the court set on July 9th of 2024.
How did she come into custody?
Driving without license.
When the police came into contact with her, when she had pulled over and was filling up the tire on her
No, just recently.
car.
No, but then
When were
she,
you arrested the last time?
how did she just
brought
recently
in.
come into custody?
I was-
She didn't come immediately back to the court.
Yeah, no, I was in a vehicle.
No, Your Honor, she did not. She said that she thought that her attorney at that time would be able to get her a new PCC date, but then her attorney withdrew. And then I was assigned on January, I think it was 9th of 2025. And then that's when she had been taken into custody around sometime in January.
No, I just came.
No.
No, I was in a vehicle that was pulled over.
So, and it was pulled over?
Yes,
And you knew at the time that it was pulled over that you hadn't shown up for your court date.
yes, I didn't.
So why didn't you come in?
Well, I did. I came in
Well,
with that.
now, yeah.
Yeah, well, at the time prior to me being pulled over, the attorney I had, Chelsea, I can't think of her last name, she's a public defender. She advised me originally, I was on the phone.
She
with her
advised you originally.
to not come, to not turn myself in.
Oh, really?
She did. And then
She
she
did?
quit.
So she told you,
And then
yes,
she-
don't come to the court
Until after Christmas.
until after
Yes.
Christmas.
Yes, and then she quit.
Why would she say that?
For the same reason that she wouldn't tell you I was on the phone with her while she was here in court.
Excuse me? Oh, she was just out to get you.
I'm not saying she was out to get me. I'm saying that
She wanted
there
you
was
to
just
spend Christmas.
miscommunication. There was a miscommunication.
So she told you not to come in until after
She
Christmas?
told me to hold off on turning myself.
Till after Christmas? Right?
Her words were,
I'm now on May 1st. When did you get picked up?
9 days ago.
9 days ago? That's well after Christmas.
Well, she had quit, Your Honor.
So,
I didn't
other
have
than the
enough-
other false statement you made about Mr. Gilles, are you saying she told you to stay out till that point too?
I didn't have an attorney.
Oh,
I was informed by the.
oh, you're
person.
just put on
I
that
think she was-
device? Yeah, okay.
Yeah, Your Honor,
I think
don't
she
wanna
was
make-
taken into custody before then because they would not have assigned me. I have proof that I was assigned on January 9th of 2025. So,
So where's she been since January 9th?
were you released and then failed to appear again?
Like I explained to you after.
And then 9 days ago, she gets picked up.
Judge, it's kind of bizarre what's been going on.
Pardon?
It's a little bizarre what's been going on.
Oh, yeah.
with the Case,
have-
and we both apologize.
Yeah.
But she has one prior conviction that was in 2025 years ago,
Don't
Judge.
blame, you know what?
I'm not
Here's
trying
my
to
problem. I almost would buy your story, but
I'm not
you're
trying to
not
blame.
gonna blame Mr. Gilles for you
Well,
not
no,
appearing. You
I'm
decided
not.
that you wanted to stay out, you wanted to
I
be
did.
out till Christmas. She did
I
not
did.
tell you that,
No,
and then
I-
you just continued to stay out. So
Yeah, I'm not
motion
trying
for
to
bond
blame.
reduction denied, bond will continue. Thank you.
Alrighty, that was fun. Ian, to answer your question, can you be arrested for changing a tire? No, but an officer is within his rights to stop and offer to render help and make sure everything's okay. And in the course of that, if he discovers that there is a warrant for her arrest, well, there you go. Let's change it up a little bit. Let's visit a new judge for this channel. This is Kristen Simmons, 54A District Court, about 90 minutes to the northwest of Judge Simpson in Lansing.
Because my client would like to run this exam. My understanding is it would be a run technique.
How many witnesses? It would just be one witness, Your Honor.
Let me do this waiver and then I will.
Sure.
Okay. On the record in the matter of the state of Michigan versus Javon Smith, 5-00706. Appearance, please.
Good morning, Your Honor. Dave Buxton on behalf of the people of the state of Michigan.
Morning, Your Honor, Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Smith.
Mr. Smith was scheduled today for a preliminary examination. There's 10 counts here. An habitual offender, fourth offense is included in that 10 count. Various weapons and I think
delivery, manufacturing of drugs, encompasses the litany of charges. He wants to unconditionally waive his examination.
I'd like to waive our exam, please.
The people would unconditionally waive as well.
That's what you want to do, sir?
Yes, I have, something to say though, as well.
Can you say that again?
I have something I have to say as well.
Yes.
I've been trying to get in touch with Mr. Freeman, but it's the last, treatment there. And today, the first day I actually was able to talk to him. I've been down to his office.
You mean since March?
Yes, I've been down to his office multiple times. They tell me that he was sick, and ill, which I understand. But, Your Honor, I feel like I've been out here fighting on my own. You see what I'm saying? I came in here in the blind. I don't really know what's going on. So he handed me a paper telling me to sign it. I just signed it, but I really don't know what's going on. He hasn't did my guidelines or anything. So I'm really in the blind.
You mean this paper? This is what you signed?
Yes,
Okay. Had you had a conversation before you did that?
yes,
The conversation, you agreed to waive your exam?
yes, I agree to waive it.
Okay, you understand that once you waive your exam, you can't decide later that you've had ineffective assistance of counsel, you want to come back and have your exam. So if your concern is that you have not been properly counseled, then you shouldn't be waiving your exam. You should be focusing on getting counsel. And I agree. I recognize Mr. Freeman has had some issues with his personal life, but that doesn't mean that your rights should be abridged and that you should not get adequate counsel. I'm not going to be represented on life offenses with someone who doesn't communicate with me. And if you're not there, then your office should send someone in your stead.
Thank you. That's all I'm asking.
I agree. Mr. Freeman?
And the court in its wisdom would have us do what after today?
Well, it's up to you. He said he hasn't spoken to you since March 6th, March 20th, actually. It's May. He's facing life.
I took some time off.
I recognize that, but his case didn't go off because you took time off. So what are your clients supposed to do? Are they supposed to just hang in limbo? Are they supposed to feel confident that they're being adequately represented if they're trying to get in touch with their attorney during this time and they don't know what's going on and they don't get an opportunity to meaningfully meet with you and go over evidence prior to this? Did you go over evidence?
No, no guidelines, anything.
How is he waiving anything? How is he properly being advised?
I indicated to my client that his end result that he's seeking is not going to be obtained in a courtroom. We have a proper time and day set up right now. Is for May 7th with the investigating officer and with the assistant prosecutor, Mr. Berman. It's all set up.
And that's just for me to find out how much time I don't know what I'm looking at all.
Sounds like you need more time to counsel with your.
I'm sorry?
It sounds like you need more time to counsel your client.
People would have no objection with an adjournment, Your Honor, if that's what we need to do.
I am going to adjourn it. He needs to meet with his client and not out in the hallway. He's facing life. May 15th at 9. May 15th at 9.
Set for another exam date or a probable cause conference?
I'll set it for another probable cause conference.
Thank you, Your Honor.
It sounds like he could have the meeting and still be waiving, but he should still first have an opportunity to be properly counseled before getting to this point. So I noted your concerns on the record. This matter will be reset for a PCC on May 15th at 9 a.m.
Thank you.
We'll get you a notice to appear. You're all set. On the record,
As is my normal procedure, I spend a little bit of time with judges before I put them on the channel just to get to know them a little bit. And I have not seen the I'm going to reprimand the lawyer side of her yet. That was fun. Let's go back to Judge Simpson.
All right, what are we doing today?
I'm in receipt of some jail calls. I need to go over those with my client, Judge. I just need another PCC for May 8th. if that's available.
You just want to pick your date, fine. All right, that's fine. What? I don't have May 8th. I have
Oh,
May
what-
15th. I can do
Um,
May 6th, I can do May 6th or May 15th.
Let's see, May 6th, Judge. Yeah, May 6th, I will be in your courtroom, Judge. That works for me, May 6th.
You're gonna be here?
Yeah, I'll be in person, Judge, of course.
Oh, boy. All right. I'll adjourn probable cause conference into May 6th, 2025 at 9 a.m.
Okay, thank you, Judge.
Thank you. Bond continued. Court calls the case, People versus Kevin Barajas Vargas.
Hey, good morning, Your Honor. Laura Yagi, Assistant Public Defender with, and on behalf of Mr. Barajas Vargas, could you state your name for the court?
Kevin Barajas Vargas.
Your Honor, in this matter, we are requesting a preliminary examination date. I would ask to address bond.
Of course you would. Is all discovery complete?
So the only question I had, and I emailed Ms. Tanha about this, we requested the 911 call last time. I'm not sure. I was just trying to see if we got it through on base. But I feel confident that we'll be able to get it before the exam.
All right, there will not,
Thank you. Appreciate
there
it.
will not be an adjournment for that purpose.
Understood, Your Honor.
So people have their witnesses available the 13th. Preliminary examination in person, May 13th, 2025, 9 a.m. before Judge Valvo. Yes, as to bound.
Thank you. So in this matter, my client is prohibited from contacting his 3-year-old daughter as well as his mother and his daughter's mother. He is charged with count 1, which is the felony child abuse for the allegation is throwing his daughter out of the door. That being said, the CPS investigation has now been closed. The body worn camera shows, and I know, it's not a trial date today, but that even the daughter's mother, denied even a medic to look. She said she's fine. She said it didn't happen when the daughter was trying to tell the police what happened. There's a lot of issues here. My client is even willing to do any sort of supervised visit if the court would even allow that to allow him to contact his daughter. This is the longest he's gone without even seeing his daughter in her entire life, and it's really difficult for him. So that would be our main request as to bond modification.
Response.
Your Honor, contact with the child victim is simply not appropriate at this time. She was 3 years old, and the report states that when they were co-parenting, him and the mother of the child, and when they showed up, he was yelling at the mom, asked her to leave, pushed her, and then he grabbed the 3-year-old child under her armpits and threw her from inside the house, outside the house, and she landed on her back and was screaming and crying. I don't think it's appropriate for him to have contact, even supervised contact at this point during the pendency of this case, which is charged as a child abuse murder.
Anything else?
I think the only difference between his initial arraignment and now is we have the body worn, which shows that the mother said, basically denied the child's allegation. She said there's no injuries, no need for anybody to look at her. She's completely fine. CPS has now closed the investigation when my client signed a safety plan with them. So I think it is excessive for him to not even be allowed to have any contact with her whatsoever, not even a phone call. This is, so I would ask him.
I'm going to wait for the point at which there's testimony, or at least Judge Valvo can look at it. So at this point, motion for bond modification is denied.
Thank you, Your Honor.
Judge Fleischer is up and running finally. Let's go say good morning to him.
Next. Okay. You are Joe Castillo. Jose Castillo. So Jose Castillo, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 23rd, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 77 miles per hour in a 35 mile per hour zone via radar detection and weave in and out of lanes around 4 vehicles, nearly causing a crash. The law enforcement officer briefly lost sight of the vehicle, but found the vehicle parked sideways in a driveway close by. The defendant was still inside the vehicle and admitted to being the driver, but stated he was only going 60 miles per hour.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I'm now also ordering you not to drive in a reckless manner, not to participate in any street takeovers, racing, anything of this nature. And if I find you do, I will put you in jail. No more PR bonds. Do you understand?
It's out of the way, Your Honor.
How old are you, sir?
18.
What do you do for a living?
I work in a warehouse.
Okay. Do you have the ability to hire a lawyer? You want a court-appointed lawyer?
I'm gonna request a attorney.
Okay. I need you to fill out an application for me. Deputy Miranda is going to give an application. I'm going to have you go to Victoria, sign and reset, and then I'm going to have you take a seat in the jury box. Do not leave until you sign all our bond conditions. You understand? Come on. Do you mind filing those conditions, please?
Yes, Your Honor. That'd be no reckless driving and no driving.
Same
without a
as-
valid license.
And then, no racing, street takeovers, donuts.
Yes, Your Honor.
All right, Judge, next is page 27, royalty.
Hold on a second. I have, ready?
I found him, yes. Is it an arraignment? It's an arraignment.
Yeah.
Last name? Gallegos.
Page 7.
Oh, I didn't even find that he was
Amber,
checked in.
there's also a co-defendant in this case.
Really?
Oh,
It's a DUI.
no. Sorry,
Oh,
you're right.
okay.
Okay, I thought come up.
Oh, that's not mine. I'm over here.
Who's yours?
He's mine.
All right, do me a favor, have a seat for me right now, we'll call you right back.
This one.
All right, stand.
You are on bond for DWI and you've now picked up a new DWI. Sir. You were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officer spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled. Another law enforcement officer was alerted to the incident and found the defendant who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me?
Yes, sir.
On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI. I'm revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we
So-
waive the fee?
Absolutely, of course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. I'll set the bond and then,
Take my card here and look, I ask you to start moving around. We'll handle this when we get the.
All right, Judge.
get whatever date you want on the new cases.
Okay.
When he posts bond on the, old case, feel free to get in touch with the, and then you can put the date
Just
for
one
whatever.
together.
Yeah,
What are
He-
you setting the bond at? I'll tell it.
5,001.
5,001.
Yeah.
Both cases or just the?
He just, no.
As a person of faith, respectfully submit one correction to Judge Fleischer's statement there. Jesus would not need a ride to church. He is already there. Just my 2 cents. But at least he's not threatening kittens in a burning building again. So we've got that going on. Let's continue to ride with Judge Fleischer as he works through his arraignments, and then we'll see where else to go after that.
Come on up.
Hi, good morning.
Tuesday, the sixth. Okay.
What was the last name again?
Mendoza.
You're Alexa Mendoza. Miss Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On April 23rd, 2025, law enforcement officers were dispatched to a traffic collision in Harris County, Texas. The officer observed the defendant's motor vehicle on the fixed rail tracks impaled to the LRV. The law enforcement officer opened the door to check on the defendant, the sole occupant of the vehicle, and observed the defendant to be impaired. The law enforcement officer observed glossy eyes and slurred speech, and the defendant stated she left a bar where she had 8 to 10 drinks of tequila and was on the way to a concert. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN. The law enforcement officer notes that the defendant threw up during the HGN. The walk and turn was a 4 out of 8, and the one leg stand was a 3 out of 4. The defendant was ID'd by her Texas driver's license, and the defendant consented to a breath test yielding a .137 and a .123.
Any prior DWIs?
No, Your Honor.
License?
Check that.
Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If you test positive, your bond will be revoked. You'll go into custody. You understand?
Yes.
You are not allowed to drive unless you have a Texas driver license and liability insurance in your name. As long as you have those, you may continue to drive. Just don't use. Do you understand?
Yes, sir.
It is awful, Your Honor.
Great. Because you have a lawyer, I will waive your appearance, but you must stay in touch with them and they'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. You'll get with Roxanne for your bond conditions and then you're free to go.
Yes, sir. Thank you.
Thank you.
All right, Judge, page 27, loyalty, come on up.
Good morning, Mr. Royalty.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, a law enforcement officer was dispatched to a Shell gas station in Harris County, Texas. Upon arrival, the officer observed the motor vehicle to have crash damage and to be disabled and inoperable. The law enforcement officer observed the defendant sitting in the driver's seat. The law enforcement officer observed constricted pupils, slow speech, and unsteady balance. The defendant stated that he was driving his vehicle before the accident and that he does not know what he wrecked into. The defendant stated he did not know where he was coming from before the crash. The defendant stated he consumed one alcoholic beverage. He also stated that he inhaled nitrous oxide approximately 20 minutes before the crash. Standard field sobriety tests were conducted. A 0 out of 6 was recorded on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer observed an empty bottle of vodka on the driver's side floorboard, an empty vodka bottle inside the center console, and a half-empty beer in the back seat. The law enforcement officer observed 3.3 liters of space gas containers of nitrous oxide and 14 1-liter nitrous oxide containers. The defendant is the registered owner of the motor vehicle. The defendant agreed to a breath test strip. However, the law enforcement officer notes that there was an interferent error and the breath test was unable to be collected. The law enforcement officer called for a drug recognition expert who completed an evaluation. The drug recognition expert stated the defendant is under the influence of cannabis and is unable to operate a motor vehicle safely. The defendant consented to a blood test and a sample was collected.
Okay. Mr. Royalty, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, and that includes nitrous oxide, whippets, anything of this nature. Do you understand? Yes, sir. If I find that you use, I will revoke your bond, put you in jail, no more PR bonds. Any priority to BIs?
No priority to
license?
eligible.
And you may continue to drive as long as you have a license and liability insurance in your name. If you don't have either, then you're not allowed to drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay. I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you, how much money you have at the bank, what you do for a living, what kind of car you drive, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Miranda is going to give you the application. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir. Sir, please.
Judge, that's it for now.
Okay. Mark Metz.
All right, bye.
What's the deal, Pickle?
We are here on Vanessa Torres. It's number VA.
Torres is the last name? Okay.
We're waiting on some medical reports from the hospital, but that's not gonna, I don't think, make or break the case. He said that he just made an offer.
Are you happy?
The reset.
Are you happy with the offer?
I haven't even seen the offer. He just.
I
told
put it
me
in
yesterday.
yesterday. It was a deferred, a classic, bid, T-Raz deferred.
So I just want some time to talk to him, and.
You're at 190 days old though, so it's time to make a decision. I'll give you a couple weeks, but
Yeah, that's
your client's got to be here within the next 2 weeks to decide what we need to do. Okay? Okay, thanks, Mark, man. Hi, Sarah, you ready?
Good morning.
Hi.
I'm here for Mr. Torres.
Have a
So I think there was confusion. No, I approached yesterday to move his DVR to today, and I never talked to Vic about it, and that's my mistake. So it's off docket. So I have the cause number if you'd like. 2509942. I also talked to the state because we were set for today anyway about the DWPTI application mitigation packet, and we've not heard back yet. So
Where is he?
right there.
Come up, Mr. Torres.
He's in the live stream out for his approach.
I'm just sending him for a drug test.
Oh.
I'm sending you for a drug test. The next time you fail the test, you will go to jail. Do you understand me? Okay, take a seat for me. Okay, we'll let you know the results.
Okay. So we just sit on the, wait for the
He needs
reset.
to come back. Then I'll, I need your. Hold on, I might. Hey, Sarah, can you leave me your cell phone and then I can text you, that way you don't have to
I'm
wait.
happy to stay. That's okay.
No, because you can always zoom in. You know?
Okay.
It's silly for you to wait.
No, don't stay, because quite honestly, the longer she stays, the more likely she's going to request that he cut the stream. So move on, please. So a couple things real quick. I just pinned in the chat a link to our newsletter, and if you're not already subscribed, I would encourage you to do so. A couple things. First off, Mrs. The Courtroom Files and I have been marketing online and doing things online for 25 years now. And not once ever have we ever sold information. So your information, your email address is secure with us. We don't even share our email lists between our own businesses. So if you sign up for the Courtroom Files newsletter, you're not going to suddenly get emails from any of our other businesses. It will just be Courtroom Files. Now, that doesn't mean that we might not put a little blurb in the email about, hey, check this out if you're interested, but you'll never get full-on emails from our other businesses even. So it's very secure. On top of that, the reason why I'm asking is around the middle of this month, probably the 16th will be the first date, we're going to start doing a weekly newsletter where we will call out some of the more interesting videos that we have, maybe share some court cases with you that you haven't seen, stuff like that. So it's a great way for us to connect. There's no cost. All I need is your email. So hit that link in the pinned chat there and sign up if you would. Bailey, the reason why I asked where you were located was I thought you were down in that area, but I was curious if you saw the case with the guy traveling through Tucson who took the hatchet to the back of the head. That one was just super senseless to me, so I was curious if you had seen that. It's I hate it when stuff like that happens in our state, because honestly, this is one of the, all in all, one of the more peaceful areas I've ever lived, so when I see something like that, it incenses me. Anyways, let's go back to Judge.
Right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change it. So you didn't want to do PTI.
Judge, we discussed it and he couldn't get the character letters together and.
It's a damn shame, Mr. Bueno, because I'm going to tell you, you had the ability to get this thing dismissed. Now you're pleading guilty to this. One day you're going to look back and say, why didn't I take the time to get it done? This will affect you for the rest of your life.
It's possible.
No, you're now at 200 days. You've done nothing. No, you've had plenty of time to get it done, not on the day of when you're set to plead. The other thing is this, Mr. Bueno, I'm going to tell you that if you come back here with another DWI, it is a minimum of 30 days in jail for anything that you pick up. Not only that, if you continue to endanger the community, a second DWI, it's a $6,000 surcharge. So get ready. If you want to get lit, find another way. Uber, Lyft, whatever it may be. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I will send it to you to the agreement. I'm going to suspend your license for 90 days, sir. Do not drive until you get a license. Good luck.
Would you be willing to waive the DPS fine?
Yeah.
Thank you, Judge.
Okay. Mr. Kim.
Judge,
Hey.
be very, very quick. Stacy's on Zoom.
Hi, Stacy.
Good morning, Judge.
You do this ahead of time. It's a pre-signed waiver, Judge. She already has a copy. I sent her by email.
Got it. Okay.
It's only because he was a.
Be here now
He's in the whole of it, yes, Judge.
Have you explained this to him?
So I explained it last time, Your Honor. I tried calling the holdover today because we were under the understanding that he had signed a waiver aside from that one. But if he can step out so he can understand what's going, because I know last time he was.
Please. Do you know the name? Okay.
Galvan?
Was there a CI offer?
Correct.
Morning, Mr. Groves. Morning. I'm bringing you out just to give you an update of what's going on with your case. You were wanted out of the state of Ohio for a probation violation for I'm assuming that's weapons under disability.
Yes, I'm not familiar with the charge. I don't know what the Texas equivalent is.
The thing is this, Mr. Groves, is that when you sign for probation, no matter where you are, you need to read the fine print. Many times when you sign, you waive extradition by virtue of signing the agreement by saying, hey, if I ever take off, I will refuse to fight extradition. And that's what's happening now. So even if I wanted to give you a bond so you could go turn yourself into Ohio, I can't because you have already waived by virtue of signing for the probation. You understand? So that means that we give the demanding jurisdiction, which is Ohio, here 30 days to come get you. Okay? Okay?
Thank you, Judge.
All right. Thanks.
Thank you, Your Honor. May be excused.
Thanks, Ms. Morgan. Hi.
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
Okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne, what the
Presumptive positive for THC.
That's it.
That's it.
Okay. I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
He tested positive on April 7th, Judge, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the
I ordered him not. Let me see. Hold on. I ordered him not to use in January. We are now.
Yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
If I tested him in early January, then I'm going to have an issue. But if it's the first time I tested him was in April, then I'm going to give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm going to have an issue. I don't remember when the first time we tested him, so I'm going to ask her. Roxanne, On Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for cancer?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
Okay. So March 11th was the first test, and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when he was a no-show. And on April 14th, it was confirmed by lab that he was positive.
No, you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother, who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that. But there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really. If I don't, I'm enabling the behavior, and that's it.
Yes, Judge. Maybe excuse me.
Please.
Okay, Vicky, Columbus still has a rule on the books that it's illegal to sell cornflakes on Sunday. Yeah, there's all sorts of weird around the United States. Stuff like you can't put a pie on your windowsill to cool on a Sunday morning. All sorts of odd stuff. I have one to share, but let's get this interaction real quick and then I'll share.
Morning. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. Sorry, I'm having trouble loading it. Okay, here we go. On April 23rd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a suicide. Upon arrival, law enforcement officers found the defendant in the driver's seat of a U-Haul truck, slumped over the steering wheel. The law enforcement officer observed bloodshot eyes, slurred speech, and unbalance from the defendant. The passenger, the co-defendant, was detained and a crack pipe fell out of the co-defendant's pocket. The law enforcement officers found foil with narcotics residue on the passenger seat of the vehicle. The defendant admitted to taking Xanax that morning, and standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The defendant consented to a blood test. A wheel witness stated they saw the U-Haul in motion, pull into the driveway of a house across the street, and then walked over to the U-Haul and saw the defendant in the driver's seat.
You said they did field sobriety tests? They've taken to the station? What?
Yes, Your Honor. Standard field sobriety tests were conducted. 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and a 0 out of 4 on the one-legged stand.
Blood test, breath test?
It was a blood, consensual blood test.
Any private of the eyes?
No, Your Honor.
Signs I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it, because I'm telling you, if it becomes a problem while you're on bond, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I'm ordering you not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you, and I'm going to test you probably within a week. Do you understand?
Yes, sir.
Do not use. If you have a problem, now is the time for you to do whatever you need to do to address it. You have the ability to hire a lawyer, ma'am.
No, I don't think so.
Okay, I need you to fill out an application for me and I'll take a look to see whether you qualify. I will have you go, oh, you said she has a valid license?
It is eligible.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name, and that is also a condition of your bond. Do you understand, ma'am?
Yes, sir.
So I'm gonna have you go to Victoria, sign a reset. Deputy Miranda is gonna give you an application. I need you to fill it out for me. When you're done, you can bring it back to us and we'll take a look. Please. Roxanne, testing in a week, please.
Okay, we are 27 subscribers away from hitting the 17,000 mark. So if you're watching here this morning and you're not subscribed to the channel, please consider doing so. Help us get over that mark. Vicky, real quick, talking about weird laws on the books. So here in Arizona, several years ago, there was an inmate in the Maricopa County Jail who had nothing but time on his hands and raided the law books and found it was still on the books from the Old West era. I still claim we're the Old West, but the real Old West. That once he was released, he was entitled to a horse and a gun. So he went to court on that and he won. So they have since removed that from the books now. But yeah, I've always been of the opinion with laws that if they're passing a law, they should also have to remove two, because our law books are way too filled, especially with old junk that nobody uses anymore. But I always found that one interesting. He had nothing but time on his hands and found he was entitled to a horse and a gun upon release. Court found with him. Let's go to Judge Simpson for a little bit.
He is gainfully employed still at Amazon. He lives with his family. He attends Macomb Community College. Prepared to test either here at Community Corrections or if we can arrange somewhere.
Why didn't he go over and test?
You know, Your Honor, he lives in Macomb, Michigan, and he tried to get over here in time. And it's a long, my understanding of where it is it's kind of north Macomb County. It's a long ride in the best of circumstances right now. I think 696 is torn up. He just didn't get here. So he did turn himself in Tuesday because transportation issues didn't allow him to do it yesterday. So he turned himself in Tuesday because that's when he could get here. But he is prepared he does have transportation now. He is prepared to test.
He returned from the Bahamas on the 21st, right?
I believe so, Judge.
So he couldn't get to test 22nd, 23rd. I mean,
that, I think he had some confusion. He has no criminal history. I think he had some confusion about the actual testing procedure. He thought he would, there was a color he was supposed to do. I am prepared to help him negotiate that.
No. We couldn't have had that, because when I gave him permission to go, specifically, he was to come back and take an ETG, and then he never showed.
Oh, okay. Your Honor, I'd ask the court to excuse that failure and allow him an opportunity to demonstrate to the court that he is a good bet to both appear and to test as required by the court. Like I said,
he's supposed to come back and test. I let him go, and then he just didn't do it. And it's not, he came back on the 21st, which is, he came back and was supposed to test on the 21st, but he didn't. That would have been a Wednesday. And he said he couldn't get here from Macomb those 3 days.
Yes,
so
Your Honor.
somehow or another, he got himself to the Bahamas, but he can't get from Macomb County to Washington County. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Yes, axiom you caught from my laughter. I did look it up. Just for anybody else who's curious, I'll go ahead and read it. This is North Carolina General Statute 67-2 entitled Permitting Bitch at Large. Any person owning or having any bitch shall knowingly permit her to run at large during the erotic stage of copulation. He shall be guilty of a Class 3 misdemeanor. So, you interpret that law as you see fit, I suppose. Our laws are crazy. Yeah. Anyways,
What do you mean?
Judge, I just want to know if I needed to submit another referral.
I have a copy of it.
Okay, so 14B states that they have not received anything in regards.
So they weren't part of the we.
It's a collective.
No, I'm not. I'm a lone wolf. Go ahead.
So Judge, we're asking for the adjournment for that purpose and
Go ahead.
He just said that they don't have anything on Mr. Coleman in regards to, the referral.
Okay, so somebody might not have gotten a copy of what we have, because I have it signed by Ms. McDuffie myself.
Yes.
From April 17th.
Yes, Judge.
So, all right. Let me then do this. I'll adjourn probable cause out to the 15th of this month. And then, Ms. Eckenroley?
Yes, Your Honor.
Would you like a copy from my file?
That would be amazing, Judge, please.
Would it?
Yes. I'd greatly appreciate it.
I'm not gonna give it to you. She made it part of the. No, we are not giving it.
We are not. Thank you so much, Your Honor.
Bond will continue. Thank you, sir.
Thank you.
Court calls the case, People versus Artist Valentine Lewis.
Andrew Childers appearing on behalf of the people.
Sorry, Your Honor.
Okay.
Sorry about that, Your Honor. Assistant Public Defender Natalie Tate with and on behalf of my client, who stands to my right, Mr. Valentine Lewis. Can you please state your name for the record, sir?
Artist Leroy Valentine Lewis.
Thank you.
Thank you, Your Honor. We're respectfully requesting to set both cases for exam. I believe discovery is complete.
People have their witnesses available at 13.
That is fine, Your Honor.
Preliminary examination in these matters will be set May 13th, 2025, 9 a.m. That is before Judge Valvo in person. Oh, these are old cases, eh? Yes, the forms are old. All right. Thank you. Bond continue.
Thank you, Your Honor.
Case People versus Contrell Cooper.
Assistant Public Defender Jay Bellinger, on behalf of but not with Mr. Cooper, Your Honor. I have tried to reach out. I've left several voicemails and an email, and I just looked to see what he might be in Wayne County Jail. I am uncertain as to that at this point, but I don't know where he is at that for the time being.
Bellinger, I went through all the whole morning not having to issue a bench warrant.
And Your Honor, Your Honor, just to be clear, you don't have to. It is a decision that's,
It is.
When in doubt, adjourn it out. Am I right?
Is that right?
That's what the saying. That's the old adage, Your Honor.
That's the public defender's motto.
I had a shirt and everything. I brought it to this court.
Bench warrant will issue for defendant's failure to appear.
Come on.
Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately.
I won't hold it against you.
And I don't care. Court does call the case. People versus Wyona Harvey. Exactly, really. Oh. Cheers. Hello,
Hello,
what's your name?
Winona Cheryl Lane Harvey.
All right. Miss Harvey, you're here without an attorney.
I would like a lawyer.
You want counsel to represent you in this matter?
Yes.
Okay, do you know what you're charged with at all?
No.
Okay. How did she? What happened to your arraignment? So nobody's talked to you since your arraignment?
No.
It says, did you refuse the public defender at that time?
I believe so.
Okay, you just may not have understood what it.
Well, he was talking kind of low. The guy that talked to me was talking low. And it happened real quick. He didn't talk to me for a short amount of time.
Okay, all right.
I would like a lawyer.
Okay, let's see if we can fix that. I just want you to know what you're charged with, okay?
And I don't believe the device they found on me was mine because there's a lot
Hold on. I don't want you saying anything about the case, okay?
Yes.
All right. You're before the court on a charge that alleges that on May 31st, 2023 at the Huron Valley Correctional Facility, okay?
Mm-hmm.
That you did make an assault on a prison employee. You understand that?
Yes.
Okay. That's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes.
Okay. And my understanding and what I'm hearing from you is you want to be represented by counsel.
Yes.
All right. See, we fixed it. Public
you.
defender's case.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Harvey. Your Honor, we'd ask for a brief adjournment if the court would consider 1 week so that we can get discovery and meet with Ms. Harvey and have some conversations regarding this case.
All right. Okay. You think 1 week? Is she housed with us currently, or she is? Okay. So here's what I have. I have the 6th or the 15th because of judging. So I have 5 days or I've got 14 days. Well, Ms. Harvey, what are you held on here on this case?
Same thing. Oh, they said they saw me go in somebody's backyard and assault them as well.
Well, let me ask you this. Is there another case besides this one holding you that you know of?
No, sir. No, sir.
Mm-hmm.
That's that. I believe that's what I was here for. They said assaulting an officer.
Yeah.
Yeah.
Okay, that's what they said you were here for.
Yeah.
One moment, Judge, we're confirming it.
Okay, yeah.
When did you get coming to?
Like
Yeah, I see that.
a week ago.
Yeah. She has. Okay. Judge, this appears to be the only matter holding her with a $1,000 10% bond. However, does appear she has an MDOC hold.
Got it. Okay. So let me do it this way. I'm going to put it on the 15th.
Okay.
2025 at 9. And I'll have her bond in this case continue. All right. That way they'll be able to take a look at everything for you. And then you can come back and see us. All right.
Okay. So I have to stay here.
You have to stay here right now. There's a bond. There's about $100 bond holding you here, but you have a hold from the Michigan Department of Corrections anyway. So if I were to let that bond go, you're going to go someplace else. You're not going to get out. Okay.
Did you just say, you said if you let the bond go, I'll go someplace else, but I'm not going to get out?
But you wouldn't get out because there's an MDOC hold.
If the judge gave you a personal bond today, Michigan Department of Corrections would come pick you up and then you wouldn't be here anymore. It'd be just more difficult for us to talk with you and meet with you about your case. So right now, this $100 is keeping you here so we can meet with you, we can get the discovery and have some conversations. And then we can try to get a hold of your parole agent. Does that make sense?
Yeah, well, I don't have a way to get in touch with my family so I could get the bond.
I'll come talk to you probably tomorrow. I don't want you to post the bond right now. Does that make sense? If you post your bond, you're gonna go to the mission back to Huron Valley.
Okay.
Most likely. So
Okay.
don't post your bond right now.
Okay.
Don't post your bond until we talk to you.
Okay.
Okay?
Yes.
Okay.
All right, you got it. Thank you, ma'am.
Thank you, Judge.
Court calls the case, People versus Sean Cotton.
Chelsea Vergils with and on behalf of Sean Cotton, who should appear via Zoom. Mr. Cotton, if you're present, please state your name.
Sean Cotton, you need to unmute and turn on your camera. And get yourself stationary. State your name.
Sean Cotton.
You're requesting an adjournment.
I am, Your Honor. May we approach?
Yes.
Okie dokie. Well, they approach and he's muted. Let's go to Judge McNally. We haven't seen him yet today.
To Officer Goldsmith's location, the white male subject fled southbound on foot. Officer Goldsmith immediately chased the subject on foot as well. Officer Porter and Officer Denson exited their patrol vehicle and also began to chase the white male subject on foot. The subject ran into the east side of the Tim Hortons parking lot located at 27035 Telegraph Road in the city of Flat Rock. Officer Goldsmith then caught up with the subject, who was still on foot. As he attempted to restrain the subject, both he and the white male fell to the ground. Officer Porter and Officer Denson then arrived and began to physically restrain the subject. The male subject continuously and actively resisted all officers and refused to put his hands behind his back. The subject broke free of Officer Porter's grip, at which time Officer Goldsmith applied 3 open hand palm strikes using his right hand to the subject's face. Officers were then able to regain control and physically place the subject's hands behind his back, placing him in handcuffs and under arrest at that time. After the white male subject was in custody, he advised officers of his name, which was Michael John Buzik, with a date of birth of 4/16/1981. Dispatch filed this name through Lean and SOS and observed 2 active felony warrants out for his arrest. Based upon the officer's investigation on 4/30/2025, I forwarded this case to the Wayne County Prosecutor's Office for reviewing the possible charges which you see in front of you. And Your Honor, I can stipulate to the 3 priors, making this a 4th offense habitual offender's notice out of the 3rd Circuit Court, where Mr. Buzik pled guilty on 7/1/2014 for home invasion in the 2nd degree. Also, another conviction for home invasion in the 2nd degree out of the 3rd Circuit Court, where he pled guilty on 11/9/2016. And then a later conviction where he pled no contest to possession of methamphetamine with the 38th Circuit Court on 5/10/2024, once again making this a 4th offense habitual offender's notice.
Based on your sworn testimony, I find the crimes of assault, resisting, obstructing officer, 3 counts committed. There's probable cause to believe those crimes were committed by the defendant. Also, that the defendant has prior to the 4th offense notice. Sir, Mr. Buzik,
Let me grab him for you, Your Honor.
Sure.
Go in this seat in front of the screen, okay?
Sir, your name?
Michael John Buzik.
Counsel?
Good morning, Judge. Attorney Corey West, on behalf of Mr. Buzik. At this time, to a formal reading.
I'm going to advise you of your rights, Mr. Buzik. You have the right to remain silent. You do not have to say, you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. And if at any time you choose to submit to questioning with law enforcement officials, you have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, Your Honor.
And we're going to set these for a probable cause conference. At the probable cause conference, your lawyer will discuss these cases with the prosecution. And if it proceeds to a preliminary examination as to each one of these counts, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, then the cases would be dismissed as to any one count that they failed to prove that as to. Do you understand that?
Yes, Your Honor.
All right, so you could, I'm just telling you could get up to 15 years on each of these counts if you were convicted of these, if it's proven you had the three prior felony convictions. Do you understand that?
Yes, Your Honor.
All right, Bond.
Yes, Your Honor, I would like you to know that Mr. Buzik currently is residing in Monroe. He is gainfully employed full-time at Roush, located now in Park. He just started working there roughly a month ago, so as you can imagine, he does need to get back to work as soon as he can. After speaking with Mr. Buzik, he did assure me he would be appearing on all future court dates and understands the importance of doing so. I would just ask that all that be taken into account in assessing the bond.
He had two felony warrants, right?
I'm just about that.
Is that right? I heard you correctly, right, Lieutenant?
Yes, Your Honor. He currently has two felony warrants. One is a $75,000 cash or surety bond with the Monroe County Sheriff's Office. That's for possession of methamphetamine, and that was entered into lien on December 18th of 2024. His second warrant is somewhat similar to this case in regards to evading police. It's a no bond, flee and elude in the third degree. That's also out of the Monroe County Sheriff's Office. And that was entered January 15th of this year, 2025.
It's hard for me to believe that you're going to show up on these when you didn't show up on those.
Your Honor, I'm trying this taken care of, and
hang on.
I want to go right from here to go see my probation officer. I want to get into a rehab. I'm finally onto a.
Shouldn't say anything. 15,000, 10%. That's the best I'm going to do. You cannot leave the state without the consent of the court or violate any law or ordinance. No contact with prosecution witnesses or officers Goldsmith, Porter, or Denson except through your lawyer. So you cannot talk to them except through your lawyer or in the process of the processing of the case, obviously. But otherwise, no contact. You cannot leave the state without consent or violate a law. You must appear in court as directed. Your probable cause conference will be in front of Judge Hessen. That will be May the 13th at 10:15 a.m. And then the exam will be May the 20th at 11:30 a.m. Any questions, sir?
How much is bond again?
You have to post $1,500 to secure your.
Or 10%?
You have to post $1,500 to secure your release. I said 15,000, 10%.
Okay.
Okay? Thank you very much.
Have a nice day.
You too. Good luck.
Thank you, Your Honor.
So the talk about public defenders, I would agree. Judge Middleton actually stated once that his belief was if you had to go to trial, you would actually be better off with a public defender because they do so much time in court and they see so many different things. He argues that they're often better prepared than people in private practice. So I thought that was interesting. Let's go back to Judge Simpson because he's not muted anymore.
Yes, it should be here by the end of this week or early Monday.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued in these cases. Thank you.
Thank you, Your Honor. Thank you, Mr. Kraft. You're all set for today.
Thank you. Both case, People versus Curtis Damon.
Good morning. Laura Yagi, Assistant Public Defender, on behalf of Mr. Damon. Your Honor, may I inquire as to whether Mr. Damon is on Zoom?
Damon? Nope.
Your Honor, I did fill out a green sheet requesting an adjournment. I I had been in contact with Mr. Damon previously. Unfortunately, I do believe he's homeless and wasn't able to connect with him on the phone. I know he was trying to get into treatment. I spoke with him about that. So I don't have a specific representation today as to his whereabouts, but I would ask if the court would consider a 1-week adjournment. I wasn't in good contact with his girlfriend, but him directly.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash. Court calls the case, People versus Aaron Daniels.
Alexander, on behalf of the people. Your Honor, Edema, the Assistant Public Defender, Fleischer Daniels.
I didn't think she was gonna do anything. I thought she was gonna be an acting ruling type of thing. Aaron Daniels.
Thank you, Your Honor.
All right, you stated your name, right? All right, what are we doing?
Your Honor, we're asking for a very brief adjournment. This is the first PCC, but adjournment would be awesome.
Your Honor, I did also want on the record, I requested the 911 call yesterday, so it should be here, right?
Thank you.
All right. Probable cause conference, May 15th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Case, People versus Fleming Davis.
Assistant Public Defender Hannah Apple.
Say your name for the record.
Fleming Davis, sir. Thank you. Good morning.
Your Honor, there is still some outstanding video. We're asking for an adjournment. I know that that request has been submitted to retrieve the video, so we should be in receipt of it hopefully soon.
Probable cause conference in this matter will be adjourned May 22nd, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor. You're welcome, sir. Court calls case, People versus Jordan Davis.
Ryan Bowling on behalf of Mr. Davis.
Jordan Davis. Thank you.
Judge, I submitted a green form. We are also in this matter waiting on some video discovery. I've reached out to Ms. McDuffie. She's working on it. Hopefully we'll have it soon. So just asking for an adjournment.
Probable cause conference, May 15th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Thank you, sir.
Thank you.
Court calls case, People versus Harold Dennis.
Stephanie Cannon on behalf of Mr. Dennis, appearing to my right. Mr. Dennis, when you are present, please state your name for the record.
Harold Dennis.
Your Honor, we are asking for a 1-week adjournment in this matter. Hopefully, when we come back, we will have a clear.
Probable cause conference will be May 15th, 2025.
Thank you, Your Honor.
9 a.m. Bond continued. Calls case, People versus Tequila, Evans Guyton.
On behalf of Miss Evan,
Tequila Evans.
Okay, I want to ask how you got named Tequila.
How does she know?
I just want to ask.
She didn't choose her
I just know my dad liked this some girl named Tequila, and my mama, she wasn't letting him name me Tequila, so they just named me Tequila, and that's her favorite alcohol.
Yeah, all right, that's fair enough.
I'm happy you did. Sorry, you're able to give him an answer.
I had to ask the
So
story.
couldn't be named after some other woman. So we went for the out. That's all right. That's fair. I
The middle
just
ground.
thought I'd ask.
Middle ground. Happy to ask as well. Your Honor, we're going to be asking for another very brief adjournment on this case. We're just going to continue plea negotiations with prosecution.
Okie dokie, that got cut real sudden like. Sometimes that happens with these crazy judges. Let's
Read it and
go back to
understand it.
McNally.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing nor a trial. Do you understand that? All right, you still wish to waive your right to a lawyer?
Yes, sir.
Not guilty pleas entered. The $100 personal bond, you don't have to post any money. I'm just telling you the bond conditions in case it doesn't resolve today. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. Do you understand all that? Any questions?
Yes.
All right, so go right out in the hall. He's going to give the file to the prosecutor and he'll set you up. And that is out of Rockwood. So we'll take that to Mr. Pelland. Good luck. Joshua Michael Zarate, 25F243398, 25F243593.
It's just a one case, Your Honor. There's two different surroundings.
Did I take a disorderly plea from you and sentence you last time?
No.
Oh, who's Ricardo?
Ricardo.
Come on back. Well, he doesn't need to, I didn't need to call that case. I'm not sure why I have that case.
That's a prosecutor review.
Oh, I see. Okay. Okay, so this one has to be taken to the prosecutor, John. Ricardo's does. Mr. Zarate, state your name.
Joshua Michael Zarate.
All right, you're charged with operating while intoxicated. You have the right to a lawyer. If you want one, I'll give you one. Do you want one?
Yes, Your Honor.
All right, so we're gonna set you up with a lawyer, and then Ricardo, you're gonna go see the prosecutor, and he can move to dismiss if you're compliant with everything. Let me double check something. And it says you're compliant, so we'll take this one.
Yeah, he had it, Your Honor, and I don't know what happened. Mr. Cayley had it. Well, I'll give it back.
Let me just double check.
He said he didn't need it.
Yeah, well, he needs to write up a dismissal. It was,
That's what I thought.
let me just double check. Yeah, it was taken under 771.1. So tell him I need a dismissal on that one, and then this one goes to the prosecutor too. But to a court-appointed lawyer first, I mean this one. So you can go out in the hall, he'll set you up with the Flat Rock City Attorney, but first you're going to talk to a lawyer, okay?
Okay.
Good luck. You're welcome. Jalisa Maria Rodriguez, 25R514-085A and B. And if you can tell Mr. Gaith, come on up, man, that this lady here was waiting last time, defendant showed late, I'd like to move that Brandon Robinson case. Ma'am, your name. Your name.
Jalisa Rodriguez.
You have the right to a lawyer. You're charged with operating while intoxicated. Be happy to give you one. Do you want one?
Yes.
All right. Go out in the hallway. I will set you up with a lawyer. And we'll go from there.
MD, your point is definitely worth, excuse me, definitely worth considering. I will say, though, that in a lot of the courts that we monitor, just because they're being arraigned, it doesn't mean that they were in jail the night before. Often, the first thing they see in a lot of these jurisdictions is the magistrate. So they've already gone through magistration. They've been granted a PR bond or posted a bond or whatever by the time they get to these judges. So that's something to consider as well. Your point is well taken, but not always the case. Let's go to Judge Mogan. You remember her from a couple of days ago when we saw the old man get his sentencing. This is her.
Parent appearing by video conferencing. We have her client, Miss Achterling, appearing by video conferencing in custody in Burnett County Jail. We're set today in this matter for a bond modification request. Are we in victims' rights compliance?
Yes, Your Honor.
We are in victims' rights compliance. Okay. So Ms. Perrin, argument for bond modification request.
Thank you, Your Honor. I think the main point that I want to emphasize I've put the request in writing, but I think I want to emphasize that she doesn't really have a criminal history. Given her age, lack of criminal history, her ability to reside with her mother, her ties to the community, that she can, abide by whatever conditions the court sets forth. I think there's sufficient reason to believe that she would comply with the court's conditions, return to court for proceedings, and would remain compliant.
All right, we currently have her on a $10,000 cash with certain conditions. Mr. Schmidt, argument?
I think it needs to remain a high cash bond. As Ms. Perrin said, Ms. Ochterling has no criminal history. This would be her first criminal offense. The NCIC only shows this case and the extradition on this warrant from Minnesota. The reason I think the high cash needs to be on this case is because when you don't have any past record of whether they appear or not, then we have to look towards whether these charges at this stage in their life would give them pause to come to court because of the severity of the charges, that is the maximum possible penalty, and the perceived certainty of conviction. This is a case where the defendant's DNA is at one of the burglary scenes. Burglarized property, stolen property was mixed in with her things. We have her messages along with Mr. Perrin's and Miss Kenneth Ochterling's messages talking about the burglaries and the property. The evidence is very strong and the severity, the potential penalties are very high. That is the cause of my concern. The victim we did reach out to that wanted to give any input on this said they oppose it because they want punishment, which is not a basis for the court for that, but we're obligated to tell the court. We do know we don't have the final restitution number, but it's going to be more than $20,000, which means the bond set is already half or less of that. So just off of what's been taken, we're concerned about doing a lower cash bond. Thank you.
All right. Any reply, Ms. Perrin?
Yes, Your Honor, I've actually never heard the fact that somebody doesn't have a criminal history, especially at her age, used as a negative in a bond hearing. But I just would emphasize that, she's lived her entire life in Wisconsin. Her family is here.
She lives in Minnesota. She doesn't have ties to this community. She lives in Minnesota.
Her mother lives in this community. This is where she resides.
All right, because I have Maplewood, Minnesota is her address. Then where does her mother live? I don't have any of that information.
If perhaps she could give you the address. I don't think I have the address written down, or I could check with her mother. But that is my understanding, that she grew up in this area and her mother resides in the area and she can reside with her mother.
Ms. Achterling?
I reside in Minnesota. Sorry.
Yeah, she's not from this area.
Oh, my confusion then, Your Honor. I'm sorry.
All right. Well, in hearing the arguments and looking at the charges and that it's reached probable cause stage, we have allegations of, there's at least 4 allegations of F felonies, 12.5 years of incarceration, $25,000 fine if convicted, plus numerous, I believe there are 8 A felonies with a total of, if convicted, 56 months, or excuse me, 72, equating to 6 years of incarceration for a total of 56 years of prison hanging over Ms. Achterling's head. Although she doesn't have a criminal history, we don't, as Mr. Schmidt says, have any assurance that she's going to appear for court. She doesn't have any connections or ties to this community. She lives in Minnesota. I don't know the tie or connection why she was in this area and the allegations arose and occurred. I don't have any job or other information presented to the court. Therefore, the court is going to deny the bond modification request. We need to set it for another date and time for a status sometime in the future.
Yes,
Perhaps.
I would ask that we not go too far out, Your Honor.
I can do May 15th at 9:15.
That may be a little too close. I do have to get the discovery and review it. So
I
can we
have
look at the
June-
beginning of June?
I have
Sorry.
June 4th at 9.
That looks like that would work.
All right, June 4th at 9 a.m. We will have a status June 4th at 9 a.m. All right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you. We will go on the record in the matter 25 CF43, State of Wisconsin versus Kenneth Achterling, and 20 for a status conference and a bail bond hearing. We have the state appearing through District Attorney Kevin Schmidt in person. We have Mr. Achterling appearing by video conferencing in custody in Burnett County Jail. We're set for this bond modification request hearing. The court has received the written request by Mr. Achterling requesting for a bail modification. He is asking for a lower bond, indicating that he has lived in Maplewood for 38 years. He has employment and that having the bail set at the current amount is a hardship, and he would like to get back to work and have the continued support of his family while allowing him to participate in the upcoming trial. We are in victims' rights compliance with him as well.
Yes, Your Honor.
All right, so Mr. Achterling, what else would you like the court to know, or what would you like to argue?
I mean, I've always made it to court in Wisconsin. There's never been a time where I haven't.
And I believe Mr. Achterling, it may have been provided that he has a criminal history, and therefore the court did set his cash bond at $20,000 cash with other certain conditions to follow to protect the community. Mr. Schmidt?
I'd ask for bond to remain what it is. Mr. Achterling doesn't have a ton of history in Wisconsin. The vast majority of it's in Minnesota, where he's from. In Wisconsin, I only see one missed court appearance. Was in St. Croix 19 CF 572, missed court in January 31st, 2020. In Minnesota, he's missed a lot of court, and most of his convictions are related to crimes of dishonesty. He has 2 convictions of financial card fraud, 1 for check forgery, and then a theft, and then a possessing large amount of drugs in a DC. He missed court in Minnesota in those cases in December of 2020, May of 21, December of 2019, September of 2019, December of 2019, December of 2020, May of 21, July of 2019, January of 2020, July of 2014, January of 2011. He also has a pending warrant out of Minnesota of an OWI case. I'm concerned that if the court reduces bond and releases him back to Minnesota, he might be made unavailable through that warrant. And due to the nature and circumstances of the offense and the evidence and the high penalties and the connection to Minnesota, I'm concerned of that as well. In addition to that, the cash bond of $20,000 is probably about maybe a little bit lower than what restitution is going to be. Thank you.
All right, the court reviews the charges against Mr. Achterling and does note that he as well has been charged with 4 felonies totaling 50 years of incarceration over his head as a maximum possible penalty if each of those charges he is found guilty. He also faces A total combined 6 years of incarceration for the misdemeanors if he's convicted of those as well. So 56 years of incarceration hanging over his head. He does have a criminal history. He may have employment, but he is a lifelong Minnesota resident, no connection to this area, no ties to the community. He has a serious history of failing to appear for court, regardless of if he only missed one court appearance in Wisconsin. He doesn't have an extensive criminal history yet in Wisconsin, but he has an extensive failing to appear rate in Minnesota. Therefore, the court is going to deny the bond modification request. I do have him currently set, or no, I don't have him set for anything at this time, but he is in need of continuing the case and moving forward. I don't believe that we have, we need to set his preliminary hearing. Mr. Achterling, have you been in contact again with the public defender's office?
Yeah, and they said they didn't have anything yet for me.
What I'm going to do is set this matter for preliminary hearing on May 15th at 9:15, May 15th at 9:15. Hopefully by then they'll be able to have an attorney for you for that preliminary hearing, and then we can get the matter moving. Once we have the preliminary hearing, you and your attorney will be able to get the discovery, be able to look at this case a little bit more in depth, and then we can go from there. May 15th at 9:15. We are adjourned.
So a lot of talk right now about public defenders. In the chat, I just linked for Ashley our video where we broke down how the public defender system works, who qualifies, stuff like that. If you haven't seen that video after we're done with the live, go give that a look, because to be honest, it's going to enlighten you on a bunch of the things that we're talking about right now, like, you know, are they from private firms, or, you know, is it a volunteer thing, or just, it's all covered there. So when you're done here, check out that link. Again, it's in the chat, and give that a look, because that's going to answer a lot of this stuff. Let's go ahead and just stick with Judge Mogan here for a little bit.
Mr. Schmidt, argument for new bail because I believe the cash has already been forfeited. He failed to make his appearance on January 9th, 2025. The court issued a bench warrant, $15,000 cash. The $10,000 cash previously posted has been forfeited and set aside for any restitution, should there be any in this case or the co-defendants. Mr. Schmidt.
I think the 15K is appropriate. The court was right to do it back then. It's an appropriate ratcheting up after the missed court on the $10,000 cash bond. Thank you.
Ms. Perrin.
Your Honor, I have not had the opportunity to speak with him. If I'm correct, he was just picked up the other day. So either I would like to speak with him in a breakout room now, or I'd like to reset the bond hearing.
Well, I am going to set cash bail at $15,000 cash, same conditions as previously posted. He failed to come to court in January. That's a significant amount of time. He knew he had court, and yet he failed to come to court. Ms. Perrin, you can make arrangements to talk with Mr. Avery, and then you can request a different date and time for a bond modification. Hearing today was simply, I needed to do the return on warrant. Otherwise, we need to get victims' rights compliance. But once you file a motion for a bond modification request, then we can ensure that victims are rightly notified, and we can proceed with a hearing that way.
Okay.
All right. Thank you. We are adjourned.
Thank you.
Oh, we need to set another date and time. Actually, right now, I'm just going to set your June 4th at 9:15, June 4th at 9:15. If you are going to file a motion for bond modification, we can get that in maybe sooner. You'll just file it, and then my assistant will be in contact with you. But I'm just going to keep that on with your other case, just so we have you appearing at the same dates and time.
Thank you very much.
All right, thank you. We are adjourned.
Okie dokie, let's go back to Judge Simmons, who we saw earlier today. Hold on, let me get that queued up here real quick. I just realized I need to do some graphic work this weekend. We've got all these new judges, and I don't have the fancy cartoon labels for all of them, so I got to get to work.
One of the misdemeanor final pretrial, Your Honor, maybe?
I don't know that it's a final pretrial. It might just be pretrial. That's what it says on my document. For dog cases, but one is an assault and battery. Defendant in custody, one felony set for final pretrial. That might be a final pretrial. On the assault and battery, that's file number ended in 7-3. And then there's a dog, unlicensed dog. And another unlicensed dog, that these were likely reset because he was going to be here today. And so his attorney should have made a notation of that. Nonetheless, what are we doing on the phone?
Your Honor, the people are gonna be asking for an adjournment, a good cause adjournment, because there is a witness intimidation file in review with our office with the same victim. And looking at the notes from our office when they reached out to the victim, Ms. Gonzalez, there was information and other information. There's information to believe that he's told her not to come to court. That's why it's my belief that's why she's not here today.
Now, when you are making these allegations of witness intimidation, are these allegations of calls that happened after March 28th?
Your Honor, our office spoke with the necessary witness on March 27th, what the note indicates. And there is information regarding her being told not to come to court.
Okay, so this sounds like information that's already been brought to the court's attention by way of the PA 53, of which we arraigned him on the 28th on, and I revoked his jail privileges pending the hearing. Okay, so there are witness intimidation charges that are being processed that has been authorized.
Not authorized. It's still in review as of March 21st is what it looks like. Date of incident appears to be March 17th.
Okay. That would be the report that I have here as well. Okay, let's see here. I'm sure.
Thank you, Your Honor. Defense would be objecting to that request as well as asking for dismissal. Mr. Stuckey has been in custody since March 17th of this year. And as the court already noted, these were matters that were brought to the court's attention back over a month ago at this point. This was adjourned originally from a previous preliminary exam date due to the court. I believe my notes reflect some unavailability of the court, and there was a necessary adjournment that was issued. People have had a month to be investigating and trying to figure out these charges. Based on the PA 53 reports I have received, it looks like that charge for witness interference was requested several weeks ago. And at this point, we're still in the stages of, are we going to authorize, are we not? And meanwhile, Mr. Stuckey's sitting in jail. And I realize these are serious allegations, wouldn't say different, but she's not here. And the people, it sounds like, can't proceed without her. So I'd ask the court to dismiss. They can reissue if it would be without prejudice.
Okay, this is a concern. You said that they're in review, so there was actually a complaint drafted by your office? Or sent to your office and reviewed, I should say?
So, to my understanding, police do their investigation and then they refer it over to PBK, and it ends up in somebody's queue to be reviewed for further charges or denial, further investigation. And looks like this case is pending in somebody's queue, that being APA Malud. which I'm sure has other things in there, this file. But nevertheless, Your Honor, this is a new charge. I think the PA 53 is the other question. That I believe could be done with an officer. I'm not sure if that was scheduled for today.
It was, I'm not really concerned about the PA 53 because it sounds like it's the same exact information as these new pending charges, and running a PA 53 while there's new charges pending
Something
would be prejudicial to the defendant. And so what I would prefer is to know that's why I wanted to confirm, is it something that's actually been reviewed or in review? So, or not the potential of it being in review. You're saying this is actually in review.
Actually in review to be
Okay.
reviewed.
I will take that. The objection is overruled. I recognize your client is sitting in custody, but we don't have to, you know how many cases are probably in the queue to be reviewed in Ingham County? There's lots. And every week, one of us takes a rotation, whether it's the prosecutor's office or it's the court, and reviewing to get through that queue. And we do not typically see cases processed within 45, 60-day period. That's relatively quick. We also do not have to, the officers, nor the prosecutor, nor the court needs to go and find this one and put it to the top of the review list just because he's sitting in custody, because the allegations stem from phone calls while he was sitting in jail, easily verifiable, number one. And number two, the allegations would, if true, would be actions he took on his own after being advised not to make contact directly or indirectly with the protected party. I have had 2 reports filed here of allegations of violations of the no contact order, along with actual quotes, and a list of jail calls was provided to the court. It's a long list of jail calls, which is why the court revoked the jail privileges until a hearing. And dismissal is not going to, I can guarantee they're probably going to reissue immediately, because they're going as far as to bring forward witness intimidation charges on this. So they have a strong belief that the witness was likely intimidated based off whatever information they got from the investigation, which again includes phone calls that were made from this defendant's inmate number while in the custody of Ingham County Jail on a recorded phone call. So your objection is heard, but it is denied. The matter will be reset. I don't know how long it's going to take for there to be a review. However, at this point, I am going to give an order that they find wherever it is in the review process and move it up quicker, just like they do whenever they want something else done quicker. So whoever is the officer that has this needs to make sure that it is signed and reviewed by a prosecutor, and that it is given to a judge to be reviewed so that he can be arraigned and that he'll be ready to move forward on all these cases on this next date that I give you.
We can do June 26th at 8:30.
June 26th at 8:30. Any additional matters for the record?
Diana, thank you.
Your Honor, if we may be heard on bond.
You may.
Thank you. Right now, Mr. Stuckey is being held on a, from what I'm seeing in our system, of 50,000. I believe that is going to be a cash surety bond on this matter. He's obviously not been able to make that bond. He will not be able to make that bond. I'd ask the court to consider him for a PR bond or some lesser bond at this time, given the fact that this has been adjourned and twice now, and that he is still in custody, and the next court date we have is June 26th. I would say that it would appear reports have been made, and if there's any more issues, he understands that more reports would be made. And I believe a GPS tether could satisfy along with other appropriate conditions for safety of the community as well as the election. Thank you.
Prosecution during this time.
Sorry, Your Honor.
Is the prosecution gonna respond?
Your Honor, I don't know what his bond is, but looking
50,000 cash short.
Okay. Oh, no, sorry, I was looking at something. No, I object to that. I mean, he's already telling us to come to court from jail. I wonder what he's gonna do when he gets out. Not in the people's position to allow that at all.
Okay. The bond is set at 50,000 cash shorty. That bond was set by the magistrate at the time the defendant was arraigned. And that bond was based on a number of factors, one being the safety of the public and the safety of the alleged victim in this, and as well as the charges. There's an assault with a dangerous weapon, domestic violence, and weapons felony firearm. At the time of the arraignment, the magistrate would have had the defendant's prior criminal history readily available to review. And if there was a bond recommendation from the office of the prosecutor, that as well would have been given to her, or she would have had that for consideration. I don't have all of those things before me today. I don't have his prior criminal history. I don't have any bond report here. What I do have is a felony file, where a determination was already made that 50,000 cash shorty would be appropriate with GPS tether. And it looks like random ETG 2 times per month. So there must be another substance related issue or aspect in this case. Nonetheless, the other issue that I now have is that since being in custody, there's been allegations of violations. I know that he's proceeding on a violation hearing, but now new charges are allegedly in the pipeline for witness intimidation. And I have a report here that demonstrates over 20 phone calls from the Ingham County Jail. I don't see how any of these things warrant a reduction in the bond. So the bond as that is will continue. Any additional matters for the record?
No, Your Honor.
You're all set. I need
Phone calls from jail going awry are definitely a thing. If you haven't looked on the channel previously, go to the channel page and there's a whole playlist on the jail phone saga, and it's all stuff that took place in Judge Fleischer's court, specifically around a defendant by the last name of Wiggins, and it was all kind of crazy. People misbehaving, what can I say? We're gonna go ahead and call it a day. Judge Fleischer's been gone for about a half an hour now. I don't know what he's doing. Other courts seem to be winding down just a little bit, and quite honestly, I need to go tend to some of our other businesses. Where's this judge out of again? She is 54A District Court, Lansing, Michigan. Lansing being the capital of Michigan. So I have noticed as I've been watching her court off stream that she sees an inordinate amount of students from Michigan State University, which is unfortunate. But yeah, that's where she's from, and that's what she does. Anyways, yeah, we're going to go ahead and call it a day for today, and I'm going to go tend to some other matters and then probably circle back to the channel later today and try to put up some more content a little later in the day for y'all. Again, if you haven't seen the video that we did on public defenders and how they work and who qualifies and whatnot, that is in the chat, the link for that, or you can just go to the channel page and find it. So check that out. It is good helpful material there. Hit the like button on the way out. Yes, please, Bailey. Also, please, if you would all be so kind, share the show with the people that you know. It keeps getting a little better every day. Today was actually our 40th live show. I can't believe I've done 40 of these things already. And I really want to keep growing this. This is a lot of fun to be able to interact and have this community together. But the best way to get there is for you guys to share it with the people that you know. So if you can post a link on your social medias or just tell Bob next door, whatever the case may be, it definitely helps us out. Anywho, We're going to go ahead and go. We'll see you tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. It'll be Arraignment Friday. It should be a busy day. Take care. God bless.